Hey everyone, good to see you all with us this Friday for Lunch and Learn. We did take last Friday off to celebrate Navajo Treaty Day. And in recognition and honor of Treaty Day, we did want to cover the nation's treaty-based rights in today's presentation. So thank you for joining. Thank you for your interest. This is a way that the Department of Justice can give back directly to the Navajo people, sharing information that you all are interested in, that can be helpful to you in your work. And so today we are joined by our Litigation Unit Assistant Attorney General Paul Spruan, who has been with the nation for quite some time, one of our all-star Haudenosaunee. And of course, we also have Sage Metaxen with us, who also has served with the nation for a number of years. I was very honored and happy to get to work with Sage under the Beguenas administration, and I'm so pleased that she's back with the team now and with our litigation unit. She previously was with our natural resources unit. So I'm going to hand things over to two of our all-star members of our litigation unit, and they're going to walk you through this presentation. So thank you guys for doing this today.
Okay, can you hear me? Yes, okay, as AG Ethel Branch said, my name is Paul Spruan Yin Xie, Assistant Attorney General for the Litigation Unit for the Navajo Nation Department of Justice. For us non-Indian Belaganas, the clan introductions are not the most exciting, Belagana Nishle, et cetera, and I'll have Sage Metaxen just introduce herself briefly, and then we'll get into the presentation. Thank you.
Thanks, Paul. Good afternoon, everybody. My name is Sage Metaxen. I'm an attorney with the Litigation Unit of the Navajo Nation Department of Justice. I've been with the nation for quite a while. I moved to the nation in 2013, directly out of law school, and started working for DOJ in 2014. I'm a member of the Wichita Tribe of Oklahoma. I'm born and raised in Oklahoma. I went to the University of Oklahoma for undergrad and law school. So maybe you sense a theme there. If anybody watches softball, I have to mention this. You might have seen that we made history last night. The Sooners beat Texas, and we won our 4th straight Women's World Series. But that's the best thing I have to say about Oklahoma today. I'll get into that later on in our presentation. Right now, I think Paul is going to start us off to discuss the background of the treaty.
Sure, thank you. Now, as many of you know, June 1st is Treaty Day, and the Navajo Nation has a separate holiday from sort of outside Memorial Day called Navajo Memorial Day as it relates to the treaty. One thing that AG Branch wanted us to talk about is sort of the background, the context of this particular document, and then several of the important legal provisions in the document that Navajo DOJ utilizes and has utilized in a number of cases, including fairly recently in the U.S. Supreme Court and the Arizona Court of Appeals. So you see right here on the cover, on the front of the slide, this, where am I pointing? This particular painting, and this is perhaps the most important Navajo depiction of the signing of the Treaty of 1868. And there's an entire booklet that lists all of the people involved in this particular painting. And as I recall and understand, this painting was done in the 100th anniversary, so in 1968. And you will see, if you go to the Navajo Nation Museum, the treaty exhibit and a lot of the background I will talk about is discussed in that particular exhibit. And you will see General William Tecumseh Sherman holding his sword. You will see Delgadito, the only leader who actually signed his name as opposed to marking with an X, who is signing on this green trable. You will see 2 young twins on the far right, which is based upon actual historical accuracy of 2 twins who they located in 1968 who had actually been there at the signing of the treaty. You also have a res dog, as it were, looking at the goings on. You have Manuelito Barboncito. And so we're going to get into who all these people are and how they're connected with this particular document. Next slide, please. So what's this? This is the natural formation behind it should be very familiar to people in this area. This is, of course, Sehuotsoy, Fort Defiance. And the natural background is, of course, what they call Canyoncito Benito, the very small break in the Defiance Plateau. And in 1851, the United States decided, with no permission whatsoever of the Navajo Nation, that it would plant an actual fort in the middle of the Nepakea, in essence, to control so-called Navajos. And right now, this is where IHS housing primarily is. If you know the Fort Defiance area, right in front of the canyon, which of course is the road that goes to Blue Canyon. There's a Catholic church that sits right over there, overlooking, essentially the trench of the creek that cut through erosion to create Canyoncito Benito. Now, as we said, this was a unilateral action of the United States government and created a lot of understandable hostility by the Navajo people, because even today, as you know, this area is fairly lush. There's good grazing grass. There's a lot of green area. There's water that almost throughout the entire year still flows through the canyon. So it was an act of provocation. And it's interesting that the community is still called Fort Defiance, because in fact, this fort only existed between 1851 and 1861. And after that, it was abandoned because of the Civil War, because they called the U.S. Army back to fight in the East during the Civil War. Then in, of course, 1863, 1864, which we will get to, it was then rebuilt for purposes of waging war against the Navajos in the Long Walk. And I want to disclaim something at the very beginning. And Professor Denendale, Dr. Jennifer Denendale, in a presentation she gave Saturday at the Navajo Nation Museum, said, yes, there are many traditional Navajos who the experience at Huelta, the long walk, that suffering, a fearing period is not something that we talk about. For purposes of our presentation today, we have to talk a bit about that context, because you can't really understand what the Navajo leaders, the Natani, were thinking at the time when they negotiated the treaty and the provisions within it, without understanding what they had experienced for 5 to 6 years before the signing of this document, June 1st, 1868. Next slide. And who are these people? Of course, this is Manuelito Hastin Chilhajine, Barboncito, and there's a painting that I have by artist Patrick Hubble right above this poster from this very photo. Barboncito is interesting because one of his Navajo names, when you look at his face, you can understand why, was Hastin Daga, Mr. Mustache. So he was quite the stylish guy at the time, so much so that his mustache gave him one of his Navajo names. Now, both, of course, were warriors. Barboncito was a medicine man. And in April 1860, Manuelito, Barboncito, and other Navajo leaders actually attacked Fort Defiance to attempt to drive off the U.S. Army at that location. Now, but for the superior firepower of the U.S. Army, they would have succeeded. But it's indicative of this level of confrontation at the time, where you have a military occupation and then resistance by Navajo leaders. Next slide. And so you have these two gentlemen. And it's interesting to think about it from the Biligana side. All of this is wrapped up in the U.S. Civil War. It's not well known, unless you happen to go north of Santa Fe to a town called Glorieta, near Glorieta Pass, that the Confederates had invaded New Mexico through Texas in an attempt to go all the way to California and to Colorado, and were actually only driven back after they had occupied Albuquerque and Santa Fe at a place called Glorieta, where their supply line was destroyed. And then they wandered back in the snow, shoeless, to El Paso, never to return again, except when they go skiing in Santa Fe. Mr. James Carleton, general on the left side, marched all the way from California with the so-called California Volunteers and turned up in New Mexico going, where are the Confederates? Oh yeah, we already chased them off. Now, unfortunately for the Apache and the Navajo, that meant that James Carleton had some time on his hands and a substantial military force. So he decided to continue what the U.S. military had decided they were going to do, which is to conquer, to engage in very confrontational, deadly scorched earth warfare to bring the Apaches and Navajos to some level of control by the United States. And of course, the guy on the right, by the way, the main road in Fort Defiance is still called Kit Carson Drive for reasons that I am entirely unclear. But it appears the Bureau of Indian Affairs felt unironically that they should name the main road in Fort Defiance after this guy. But this is Kit Carson. And of course, he was ordered against allegedly his own interests by General Carleton. You shall go and you shall wage war against the Navajos and find them where you find them, capture them, and of course, collect them at Fort Defiance, renamed Fort Canby, and then put on the Long Walk. And again, we have to talk about these very unfortunate, negative, devastating consequences. I believe Professor Denadale referred to it as the Navajo apocalypse, where not just one walk, but a series of walks from starting at Fort Defiance all the way to Huelde, to Bosque Redondo, to Fort Sumner in southeastern New Mexico. Next slide. Now, there's very brave, courageous stories of Navajo resistance during this time. This is, of course, Fortress Rock, which is at the confluence of the two canyons in Canyon de Chelly, Canyon del Muerto, and then Canyon de Chelly. Next slide. And there are stories of Navajos staying on top of the rock and coming down and getting water and other supplies when the U.S. Army had invaded through Kit Carson Canyon de Chelly. So for essentially 4 years, Navajos were held against their will at Bosque Redondo as part of this Christianizing project that even people in the U.S. Army ironically refer to as Fair Carletonia, as James Carleton's great experiment, which was an absolute devastating disaster because of locusts and drought and just the most horrible conditions you can possibly imagine. So, of course, Navajo leaders, including Barboncito and Manuelito, said, how do we get out of here? How do we go back to the Nepequea? What can we do? And so, again, through oral history, there was a bead ceremony with a coyote, where a bead was put in the mouth of the coyote, and the coyote went in the direction of the Nepequea. And that gave Navajo leaders hope that, in fact, they were going to be able to negotiate their return back to the Aboriginal territory for Sacred Mountains, the Nepequea. Next slide. And here are the principles involved in the negotiation of the treaty from May 30th to June 1st, over 3 days. And there is a written transcript in English of the conversation. Now, when you read it, you're left with the impression that Barboncito was having a direct conversation in English with this guy on the far left, William Tecumseh Sherman. Now, this is the same William Tecumseh Sherman who was the most famous general, other than Ulysses S. Grant, for the Union during the Civil War, famous for crushing the Confederacy by burning down Atlanta and then marching all the way to the sea, destroying everything in his stead until they reached Savannah. The most respected and feared and most devastating general. And this guy decided, instead of running for president, like Ulysses S. Grant did, he was going to go west, and he was appointed to this thing called the Peace Commission. And Congress created the Peace Commission to make peace with the tribes after the Civil War, given the devastating experience. Both in the North and South, they said, war should cease. We're going to negotiate with these so-called hostile tribes and create reservations, and everything will be okay after we do that. Just below William Tecumseh Sherman is a man named Samuel Tappan, who is considered more the civilian side of the Peace Commission, and they arrived at Bosque Redondo dedicated to the idea that they were going to convince the Navajos to go to Indian Territory, which is now Oklahoma, as Sage referenced. That was their motivation. That was their purpose. That was their intent. So they showed up saying, hey, Navajos, we've got a deal for you. It's the greatest place ever. You'll love it. It's beautiful. And don't worry about going home. You need to go to Indian Territory. So, hey, we'll send you over there and you can take a look at it. And if you like it, you can go. Now, Barboncito was selected to be the lead negotiator. And he said, oh, yeah, no, nope, not going to happen. Never in a million years are we ever going to agree with that. You said this place was nice and it's garbage. So we're going home and that's all there is to it. Now, you're William Tecumseh Sherman, fear general of the Union. He says, okay, fine. We will negotiate creating a reservation in your Aboriginal territory, and you can go home. By the way, to the right of Samuel Tappan at the bottom is Jesus Arvizo, who was the interpreter. Because when you read the background of the treaty, in fact, the conversation was from Navajo to Spanish to English and English to Spanish to Navajo. And that was the communication. Now, you can imagine that the nuances of the discussion may have been lost through this 3-language translation, but that's how they did it. Next slide. Now, what did the Peace Commission tell Congress they were supposed to do? Well, here's a list of the things. Now, for our purposes here at Navajo, it's interesting because the route of the railroad, which runs through Gallup, had already been mapped out. So they knew where they wanted to put the Transcontinental Railroad. So Congress said, when you're making peace with the tribes, make sure you do not block access to this railroad. Now, who was the only tribe that they negotiated with during this time who was in the way of the railroad? Navajo. And so this was one of the main motivations of William Tecumseh Sherman and the Peace Commission, was if you're going to create a reservation for the Navajos, make sure it's not along the route of the railroad. Now, for historical reasons, Navajo has expanded since then, but at the time, of course, it was far away from where the Transcontinental Railroad line is. Next slide. Now, this is in the council chambers. This is part of the Gerald Naylor mural that runs in the opposite direction it should within the Hogan-shaped council. This is over by the door to the left when you come in the front door. And this is a very interesting panel because he depicts, as we will see, the negotiation of the treaty. And this is consistent with other oral narratives that have come out. Jennifer Dennett-Dale discovered one in the Newberry Library in Chicago. There's actually another one in a anthropological text. And it's talking about the role of Navajo women. In between the official negotiation that appears in the transcript, Navajo women took it upon themselves to engage in advocacy to convince, in fact, William Tecumseh Sherman and the other federal people not to go to Oklahoma, but to go home. And there are various oral narratives that credit Navajo women specifically with convincing Sherman. And here's Sherman. I don't know if he's blushing, he's embarrassed or sunburned or whatever, but Navajo women are accosting him, confronting him, and saying, this is what's going to happen. We're going home. We're not going to Indian Territory. And so from a Navajo perspective, that's part of the narrative that does not appear in the specific transcript. Next slide, please. Here's above the entrance in the council chambers, Gerald Naylor's depiction of, and this is probably Barboncito, it looks like, shaking hands with, again, sunburned or embarrassed William Tecumseh Sherman. He looks a little more balding in this particular depiction. Next slide. Now, what does the federal government think a treaty is? They think it's a bilateral agreement between sovereigns. It actually appears in the U.S. Constitution, Article 2, Section 2. It's the exact same provision for international treaties, say with China or Britain or whatever. And it is included in the Supremacy Clause in Article 6. And treaties were entered into Indian tribes until 1871, when Congress said no more treaties. Next slide. And this is what the U.S. Supreme Court has said Indian treaties are and what their concept are. That tribes are retaining rights unless they give them up in a treaty. Importantly, to understand what a treaty means, you look at it from the tribal perspective of the leaders at the time as to what they were thinking the treaty should mean. Not what the U.S. necessarily thought, but what the negotiators at the time. So when we litigate these cases in federal court, one of the questions is, what would have Barboncito or Manuelito or Ganado Mucho or Delgadito have thought these words meant? What was represented to them by General Sherman in the transcript, but also what did they think just completely around in the context, given what they were dealing with the Longwa, Canhuelde, and this kind of thing? What do these words mean? And if there's any ambiguity in the treaty, of which there are, because their general provision is English, you resolve these ambiguities in favor of the tribal position. Next slide. So this is a quote from a Millock U.S. Supreme Court case. We look beyond the written word. So you don't just look at the text of the treaty, but the larger context, including the history, the negotiations, and the practical construction adopted by the parties. So the long walk and what the Navajos experienced at the time is entirely relevant as to how we think about the English words that were put in front of them by the federal negotiators. And by the way, they were shopping around a boilerplate document, what we call that. This same treaty is almost identical to that which they gave the Crow, the Ute, the Sioux, the Cheyenne, Arapaho. But does it matter that the Navajo leaders would have thought about it from a different perspective? And the answer is yes. Next slide. So one of the important aspects of the treaty, at least as federal courts have done, and this is based on advocacy by attorneys, including at DOJ, it broadly recognizes the sovereignty of the nation as a sovereign tribal nation, as a government, not as a race, not as an ethnic group, not as just a random smattering of people, but as an actual government-to-government agreement that needed to be approved by the Senate under the constitutional provision that relates to treaties. Next slide. So then the question becomes, as we said, if this treaty is identical to the Crow Treaty, the Sioux Treaty, the Ute Treaty, what's the difference? Is there a specific Navajo meaning? Next slide. From a Navajo perspective, at least as has been discussed by various scholars in Hatatli and the Navajo Supreme Court, the Navajo referred to as Naltsos Sane, the old paper. And the Navajo Supreme Court refers to the treaty as a sacred document, the primary organic law in reservation matters, similar in some sense to the Constitution. And then the court also is very aware that it arose out of the Navajo experience at Huelde as Bosque Redondo. Next slide. And there have been some statements in Navajo. These are the translations. The treaty done by our ancestors was done for the purpose of guiding us into our future as Navajo people. Next slide. This is another statement. They overcome adversity through the protective way to restore peace and harmony. By defending the Navajo way of life, our ancestors restored peace and harmony with the United States. And these come from Navajo Supreme Court opinions. And so one of the things, if you're interested in this topic, is see what the Navajo Supreme Court has said about this, how it has conceptualized this document. It's not just a federal document. It's not just an outside. Our own courts and leaders and Natani have taken the treaty and said, this is what it means to us. Next slide. So interestingly enough, the Navajo Supreme Court says, not only do we care about what the negotiators at the time, Barbancito, Manolito, et cetera, think, but we also look at the contemporaneous understanding at the time, but also what Navajos today understand the document to mean. Not just what they meant in 1868, but what do we think about it in 2024, which is kind of a different perspective from sort of what federal courts think, where it's kind of frozen in time. You know, Barbancito and Manolito is kind of like originalism. You know, what did Thomas Jefferson think of, you know, whatever, COVID? You know, well, he wouldn't know because he wasn't here. Therefore, Barbancito and Manolito, what would they have thought about the current issues facing the Navajo Nation? I don't know. So the Navajo Supreme Court, well, let's also think about what we think of what it means. Next slide. And here's a list of some important Navajo Supreme Court cases, including Russell Means from 1999, where the Navajo Supreme Court has said that the treaty, and there's a Badman clause that Sage will be discussing, means that the Navajo Nation has criminal jurisdiction even over other tribal members of other tribal nations. Then there's important Dale Nicholson Trust, Ford Motor Company, et cetera, and I encourage you to read these cases. Next slide. And Sage will take it from here and talk about some of the specific provisions of the treaty that are important to Navajo law and government. And then we'll come back and talk about some of the important modern Supreme Court state cases and Navajo statutes that have implemented the treaty. So go ahead, Sage. Thank you.
Thanks, Paul. Good afternoon again, everybody. I want to apologize first. I'm not going to be as entertaining as Paul. But second, I'm sick right now. I'm dealing with a cold, so I'm going to go off camera and I'm going to try to mute myself if I'm coughing, but I apologize in advance for that. I'm going to be discussing first some of the specific articles in the treaty and then the treaty rights that are guaranteed by those provisions in the treaty and how we use those in our litigation. Oops, sorry. So first here, starting at the beginning, Article 1, This section promises to cease any war between Navajo and the United States. It promises peace between the two parties. But more importantly, at least in the context of the treaty rights that we continue to rely on now, this section discusses the punishment of bad men. Paul touched on this. And he also mentioned that this is one of those sections of the treaty that's nearly identical in all the Peace Commission treaties. So you can read the language up here on the screen. It basically says that this is the federal government's responsibility. It's their responsibility to arrest and prosecute non-Indian bad men who commit crimes against Navajos. And this clause was included in the treaty for a practical reason. At that time, when they were negotiating and when the reservation was being created, there were illegal settlers moving on to Navajo land and encroaching and interfering and causing problems. So this was put into the treaty to hold the federal government responsible for prosecuting these people who were coming in, these bad men who were causing problems for Navajos who were just trying to live peacefully on their own land. And this was put in to make sure that these people would be held accountable by the federal government. And like Paul said, you can read the negotiation transcript from the treaty negotiations, and you can see what the parties are thinking at the time that they're writing these provisions and putting this into the treaty. Why did they put this into the treaty, and what did it mean to them? So you can see in the transcript that Sherman was promising the Navajo leaders that the federal government was going to stand between the Navajo Nation and outsiders who might attack them, and also saying that if that does happen, if someone comes in, outsiders come in and trouble Navajos, that Navajos need to go to the nearest military post, report it, and those people, the bad men, will be punished who are troubling Navajos. So you can see that Navajo negotiators, the leaders, then understood that this meant the federal government was taking this responsibility on to arrest and prosecute non-Indians who are coming on to Navajo land and causing problem. So how has this been applied now? Other tribes and individual Indians have used this provision of their own treaty in different ways. So we've seen cases where people have sued the United States for torts or wrongs that were committed against them. And they've also used this provision to hold the United States responsible for a duty to provide protection or law enforcement on their reservations. But for us, we've most recently relied on this section in the criminal jurisdiction context. So I'm going to discuss a case where we've specifically relied on this provision to argue that the bad men clause bars state criminal jurisdiction in certain circumstances. And I'm going to talk about that in a few slides, but really I just want to highlight that this provision of the treaty isn't just, a relic of the past. These words still have meaning today. We still rely on these words today. Our police officers rely on these words today to keep our communities safe. So this is a good example in the treaty of how the nation uses our treaty on a daily basis and how we include this provision in our litigation even up to the present day. Okay, next is Article 2. This is another crucial article of the treaty. It starts out just by defining the boundaries of the reservation as of the date of the treaty. So we know that the reservation didn't stay within those boundaries. Over the years, it expanded, but you can see the language from the treaty up here on the screen. At that time, it was describing the locations and the boundaries of the reservation. So you can see the familiar landmarks, what they used to describe where the borders would be. You see Fort Defiance and Canyon de Chelly. But this provision goes on and to do something else. It's also important because it's setting this land aside solely for the use of Navajos in the occupation of Navajos. So you can see the language here at the bottom. It says that only Navajos and people that people Navajos are permitting can come onto Navajo land. The United States is also promising in this provision that nobody is ever allowed to pass over, settle upon, or reside in Navajo land. that excludes like officers or soldiers or basically the federal government or people that Navajos are accepting or permitting onto their land. So from this provision, we get a few things. First, we know that this is the land set aside for the Navajos, and it's set aside exclusively for Navajo use. And second, the nation has the right to exclude non-Navajos from Navajo land, from coming onto Navajo land. So together, this means that the nation has jurisdiction over the conduct and the activities that are taking place within our borders. In other words, the nation has regulatory authority. We have the ability to enact laws and to regulate what's happening within our boundaries. And we also have jurisdiction in our Navajo courts to decide matters of law that are taking place within our boundaries and under our own laws. So this treaty provision has been used in a lot of cases, not just by the nation, but many cases discuss this provision from different tribes, right to exclude, and their treaties and what powers that gives them in a lot of different contexts. And it goes back many years, but it is still used today regularly, and it's still used by us at the nation. Paul's going to touch on how we've applied this provision in recent litigation that we're involved in. So that will be coming up in a few slides. Next is Article 6, Education. This provision of the treaty promises to provide education and basically everything that's necessary to educate Navajo children. So it's promising that kids have to attend school, that the United States is going to provide a schoolhouse, they're going to provide a competent teacher. So we've used this provision as well. If you're familiar with the Burkine victory that recently upheld ICWA, we cited this provision in our brief at the Fifth Circuit to show that the United States has this duty to promote the general care and education of Navajo children. So basically, we were arguing that ICWA really just reflects these treaty promises to provide for and care for Navajo children. Okay, next here is Article 9. This section of the treaty cedes all of the lands outside the boundaries of the reservation created by the treaty. So basically, the nation was giving up all their rights to any of the lands outside those boundary lines, except for the right to hunt. So the nation retained the right to hunt on occupied, ceded lands outside the treaty lines. And this is an issue that still comes up today, just like all the others. This provision of the treaty, we have an MOU with the state of Utah to implement this provision and off-reservation hunting rights for Navajo members. So the MOU outlines benefits to Navajo hunters, it outlines terms of licensing, it does some other things. And it also pops up in cases from time to time. There's a nearly identical provision in the Crow Treaty that came up in a case called Herrera, where the Supreme Court found that statehood, so when states become states, that doesn't terminate this right, this treaty right to continue hunting on ceded lands. And it also said that even if a U.S. forest is created on those lands, it doesn't mean that that land is occupied for the sake of this treaty right. So it doesn't cut off our treaty rights. Another interesting issue that comes up from this section of the treaty, since it gives up rights to any lands outside the treaty defined lines, how does that impact Eastern Navajo? So, we have Navajos who are living on lands in Eastern who are technically, don't have property rights, at least under the treaty, since it's outside those boundaries that were originally drawn and technically on federal public land. So that's another issue that we see today that comes or is related to this article of the treaty. Okay, the last part of the treaty I'm going to talk about is Article 13. This section of the treaty, the Navajo leaders are promising to make the treaty reservation their permanent homeland. So if you read the treaty strictly, that means that any Navajos that aren't within those boundaries, that leave those boundaries, they're surrendering their rights under the treaty. But in reality, we know that many Navajos were returning from Bosque Redondo at this time. They're settling back in their traditional homelands. And those were outside these invisible lines that were drawn by the treaty. We know that after the treaty too, that the president issued several executive orders that expanded the nation's lands up through the 1800s. It didn't just stay the original treaty reservation. And then there were more lands that were added in even more modern times. So you can see that reflected in this map up here. It's showing the original boundaries of the treaty reservation and then the various expansions in the years that those took place. So I think that's pretty cool. A lot of times you see other tribes have their land base diminished or their reservations diminished or reduced over the years by the United States. But the nation was able to actually expand their land base by quite a bit. So as it relates to the treaty, this article becomes important in these situations because the question arises, do the provisions of the treaty and the treaty rights and the protections found in the treaty, do they apply to these other lands that were added after the treaty? We, of course, take the position that they do, but again, this is a question that still arises today related to this provision of the treaty. So we talk a lot about the treaty and the treaty rights and tribal sovereignty, but how do we actually practice this in real life? I'm going to talk now about treaty rights on the ground. I'm going to highlight some cases that we've implemented our treaty rights in. We believe really strongly in the nation's treaty rights here at DOJ. We work really hard to protect them and assert them actively in our cases. And so we do argue our treaty rights, I would say, in almost every case that we litigate. But here I've just highlighted 3 for you to see how we apply these in different ways. And then Paul's going to cover a few more cases as well to show how we've applied different provisions in different situations. So the first case I have up here is Oklahoma v. Castro Huerta. The nation participated in this case as amicus. So as amicus, that's just another way to be involved in a case when you aren't a party. Amicus briefs are known as friend of the court briefs. So for the nation, we join in this way if we have an interest in a case, or maybe we see that a case is going to have some type of impact on the nation. We're able to submit these briefs to make sure that the nation's position is heard in the case, even though we're not directly involved in the case as a party. So that's what we did here. And in our brief, we focused on the nation's treaty. And specifically, we focused in on that Badman clause that I mentioned from Article 1. So we teamed up with other Peace Commission treaty tribes that had that same Badman language. And we argued that our treaty, shows this policy. Basically, it shows that state jurisdiction is excluded on the nation's land because the Badman clause vests the authority exclusively with the United States. And generally, we argued that our treaty reinforces our inherent jurisdiction and the fact that states don't have any authority or jurisdiction on our lands anyways. So we really centered our treaty in arguing this case. Unfortunately, though, it was a disappointing case. I think for the first time ever, the Supreme Court held that states have concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country. Kind of a tongue twister, but basically the court decided that states now have jurisdiction over these crimes along with the federal government. So this case was really a response from Oklahoma after the historic McGirt decision the year before. That was another treaty case, and that determined that land reserved for the Creek Nation and their treaty was still considered Indian country. And that's another situation where several tribes in Oklahoma had really similar, maybe identical treaties. So McGirt essentially transformed about half of Oklahoma into Indian country. And that was a great victory, obviously, for Oklahoma tribes. The state of Oklahoma didn't like that. And so Castro Huerta was their attempt to come in and overturn McGirt. So I guess at the least, we didn't get McGirt overturned, but the Supreme Court did decide to rule on this state jurisdiction issue. So from the beginning of the opinion, you can see that it's basically the opposite of what Indian law has said over and over again for hundreds of years. The dissent called it a huge mistake or a huge, historical inaccuracy. And it's true, but this was the decision of the court and what we have to deal with. So in their analysis, they decided that the Constitution allows states to have jurisdiction in Indian country, and that Indian country is actually part of a state, not separate from the state. They looked at a few different things to get to this point, including the Oklahoma State Enabling Act, which is basically the law that makes Oklahoma a state. But for our purposes, there's one part of this opinion that is really relevant to the nation. So along with that, the court discusses that a limiting treaty obligation could limit a state's jurisdiction. They didn't find that limiting treaty obligation in the Cherokee Treaty that they were discussing here, but for the nation, we think it's pretty clear that we have that limiting treaty provision in our treaty. We have this whole line of cases, which I'm going to talk about a couple quickly next, that basically say the nation has sovereignty over their own lands and it's outside of the state's authority. So this is especially true on the Arizona side of the nation, which I'm mostly going to focus on. And the dissent and Castro Huerta picked up on this. They pointed to those cases. So this was overall disappointing for Indian country, but we don't really think that this case has the same impact on the nation, and that's due really to the strength of our treaty and all of these strong cases we have affirming the strength of our treaty. So next, I'm going to talk about an older case to kind of lay the foundation for the next case, which is more recent. So this case is Williams v. Lee. This is a case that was decided back in 1959 by the Supreme Court, and it dealt with a trader who ran a trading post basically on the nation. He tried to file a collection action in Arizona State Court against some Navajo customers for stuff that they purchased on credit. But the court came back and said, no, Arizona, you don't have jurisdiction to hear this case. States lack the power to regulate Indian activities on Indian land. So the court looked at the State of Arizona Enabling Act, just like I mentioned in Castro Huerta. But here, the Supreme Court found that Arizona had expressly disclaimed jurisdiction over Indian lands in their Enabling Act. So that wasn't present in Oklahoma, but we have it here. And the Supreme Court also looked at the nation's treaty. So they're looking at Article 2. They're seeing how the treaty is setting apart the nation's land for our permanent homeland, how it allows the nation to exclude anyone outside of their homeland. And so from this, the court decided that this means the nation has exclusive jurisdiction. State jurisdiction would undermine the nation's authority over their own affairs. It would have infringed on the nation's rights to govern their own people on their own land. And so that was a really strong case for us, and it's never been overturned. So it was actually reinforced in Arizona State Court, which is the next case I'm going to talk about, in the final case. So that brings me to a recent case we participated in, Medina versus the estate of Cody. This is another case that we filed an amicus brief in. It was in state court at the Arizona Court of Appeals. And we got involved really to protect and assert the nation's treaty rights. And I think it ended up being a great victory for the nation. So the underlying issue in this case was a sad situation where Colombian tourists from the country of Colombia were in a fatal car accident with two Navajo tribal members on the nation's lands on Highway 89. But really the issue in the case was who has jurisdiction over that? Who has jurisdiction over Navajo conduct on Navajo land? So that came up because after the tragic accident, Medina filed a claim in Arizona court against the Navajo defendants. And so she was directly attacking the nation's authority and the nation's jurisdiction. We felt it was really important to get involved. And of course, we argued that the nation has exclusive jurisdiction over our tribal members on our tribal land, not the state. look at the treaty. State jurisdiction would infringe on that. It would infringe on our treaty rights and the nation's exclusive jurisdiction. So we discussed the treaty. We relied a lot on Williams v. Lee, which I just discussed, and we were really happy with the decision that we got. The court found that the non-tribal plaintiff, Medina, can't force a non-consenting tribal member into state court for something that took place on tribal land, even if it took place on a state highway. So if you read the opinion in this case, it looks a lot like our amicus brief. The court basically shot down all of Medina's arguments, including an argument they tried to make based on Castro Huerta. And instead, the court cites over and over again to the treaty and to Williams v. Lee. They completely reject Medina's attempts to overturn Williams v. Lee. And so from this case, we got the Arizona court to basically uphold our treaty and uphold our right to be free from state court jurisdiction over Navajo members acting on Navajo land. So I think this was a really important case for the nation and reinforces the nation's sovereignty, and it pretty much fully relied on the nation's treaty. So that is a great victory for us. I'm going to hand it over to Paul to discuss a few more recent cases that we've been involved in.
Okay, thank you, Sage. Now, this is one that's been pending for quite some time, and it involves the Window Rock Unified School District, the school district here in the Window Rock Fort Defiance area. Of course, they utilize a number of parcels. The elementary school, which is now over there, over by the president's house here in Window Rock. And then several parcels in Fort Defiance, including the original Window Rock School District, right next to where the middle school is, the football field, or at least the old football field, since they are constructing behind the event center now the new football field. And of course, the event center, the giant basketball stadium, next to the high school, and then the intermediate learning center next to Indian Health Service, next to Fort Defiance. And then, of course, you have the school housing parcel, which is also next to the high school. All of those are separate parcels of tribal trust land owned by the Navajo Nation that this school district leases through actual leases with the Navajo Nation. Now, what is the Unified School District? Well, it is a state organized entity. And it's interesting when you look at the history of this, and this is something that we're looking into right now for reasons we'll talk about in a second, where it was actually the Bureau of Indian Affairs in the early 1950s that facilitated the creation of this state entity called the Window Rock Unified School District for purposes of giving them federal funding to construct these schools in the Window Rock Fort Defiance area. But the board is elected under Arizona state law. The teachers and other staff members from the perspective of the school district are employed under Arizona state law. But then the question becomes, under the Navajo Nation's employment laws, that is the Navajo Preference and Employment Act primarily, can employees file things like violations of Navajo preference if you hire a non-Navajo? Can, if they're fired by the school, sue under our law, which goes to the Office of Navajo Labor Relations first through a charge, and then ultimately to be heard by our Labor Commission? Is there sovereignty, if you will, over this state school entity utilizing our lands? And if so, where does our power come from? Now, the Window Rock School District's defense in the Labor Commission, and then they went to federal court and went all the way up to the U.S. Supreme Court, seeking the U.S. Supreme Court to take the case, which they denied in 2017. Their argument has been, we are an Arizona state entity. We are completely immune from any regulation by the Navajo Nation. The fact that we utilize their land, that's not sufficient. In essence, it's an embassy with diplomatic immunity, and our employment law is governed by Arizona law, and Navajo Nation cannot interfere with it at all. That is the position of the Window Rock Unified School District. So they sought to dismiss several employment claims that were filed against them in the Labor Commission under the NPEA. They did not go through the process of challenging jurisdiction in the Labor Commission and in the Navajo Supreme Court. They went straight to federal court, and they said, stop the Labor Commission and the Navajo Nation from hearing our employment claims. And this is where DOJ came in. We have to defend the sovereignty of the nation when it is attacked in federal court. And what did we do? We argued the treaty right to exclude in Article 2 in the Treaty of 1868 means whoever utilizes Navajo land, no matter who they are, whether they're a state entity or not, is subject to our regulation, period. Now, there's an interesting line of cases in a case called Montana v. United States, where ultimately the U.S. Supreme Court has said, well, no, there's no automatic tribal jurisdiction. Even on tribal trust land, you need to prove up your jurisdiction by providing proof of the exceptions to a general rule that tribes have no jurisdiction over non-Indians and non-Indian entities. And for this purpose, they considered the Window Rock Unified School District, even though its entire governing board is made up of Navajos who reside on the reservation, it is a state entity, therefore it is a non-Indian entity. So the question became, do we have to follow Montana v. United States and fulfill these exceptions or not? And we argued successfully in the Ninth Circuit Court of Appeals. I personally argued in San Francisco. The treaty right means we don't have to follow Montana. And that continues to be the rule so far, at least in the Ninth Circuit Court of Appeals, which includes Arizona, though not New Mexico and Utah, which is in the 10th Circuit. We've never had an opportunity to litigate this particular issue directly in New Mexico and Utah, but it's out there. And so it got sent back to the Labor Commission, and it's been pending for a number of years in the Labor Commission, primarily because the case was stayed during the COVID pandemic because we, the nation, were getting expert reports on things like the historical origins of the Navajo, of the Window Rock Unified School District. But the main point of this is we are today in 2024 utilizing Article 2 of the treaty, which talks about, as Sage talked about, that no non-Indians shall cross, settle, blah, blah, blah. And the United States, as one party to the treaty, promised that that would be the case, that no non-Indian can settle on Navajo land. Now, that means, as has been interpreted, as the Navajos would have understood it, if we're going to allow non-Indians, such as myself sitting here in Window Rock at DOJ, to sit here in Window Rock at DOJ, you do it with the permission of the tribe. And the tribe can kick you out. They can kick me out. There's Say Benito, start walking. And that's arising out of Article 2 of the treaty right to exclude. So really, where is this going? Well, it could go all the way back to the federal courts again on this question, and it could go all the way to the U.S. Supreme Court. Will the U.S. Supreme Court uphold our treaty right to exclude, meaning we have direct jurisdiction even over the state educational entity because of our treaty? And that's one of the reasons why the treaty is still so important for legal matters today, is because of that question. Next slide. Now, this is an interesting from a criminal procedural perspective. Now, as you may know, for certain types of crimes committed by Navajos or other Indians within the Navajo Nation, there's tribal jurisdiction, but there's also federal jurisdiction at the same time. If a Navajo commits a murder, he or she can be prosecuted, or they, by the Navajo Nation through our Office of the Tribal Prosecutor and by the U.S. Attorney's Office of whichever state overlapping the Navajo Nation it occurred, New Mexico, Utah, Arizona. But how does that translate to on-the-ground situations where a Navajo is picked up by tribal police, they're being held in our tribal jail, let's say pending initial arraignment, maybe it's over the weekend, for public intoxication, reckless driving, whatever. And then the federal government, through the U.S. Marshal's Office or the FBI and the U.S. Attorney's Office, said, you know what? We'll take care of this. We'll prosecute this person. You give them to us and we'll ship them to Albuquerque, Salt Lake, or Phoenix, which is what happens. Now, there had been for a long time a policy called badging out. It was the official name of this policy by the Office of the Prosecutor, that if the FBI, the U.S. Marshal Service shows up and say, we want this one, and this one for federal prosecution, go ahead, take them, go ahead, no paperwork required, just take them out of our jail. And what happened? The day of the arraignment, the tribal judge, the Navajo judge, sits there and goes, where's the defendant? And the prosecutor says, well, they're in federal custody. And the tribal judge said, well, okay, I guess I dismissed the case. The person's not here. That was reversed. That was reversed around 2012 because of an assertion of our treaty rights under the Bad Men Clause. And there was an amendment by the Navajo Nation Council to Title 17, which is our criminal code, to create what we call the federal detainer policy. And it basically says, pursuant to the Badman Clause, if a crime is committed by an Indian, upon proof made to the Navajo Nation, they will agree to turn them over. That's what the treaty says. However, the federal criminal people, the investigators, need to provide actual proof. They can't just walk in and badge people out. You, and you, come with us. There's a process, and there's a written process, and there's you have to supply the warrant or whatever proof it is of what this person is accused of under federal law. And the person has the right to request a hearing to contest being transferred to federal custody. Next slide. Now, this one is something that we've talked about before. This is the Arizona versus Navajo Nation, the breach of trust water case. And as you know, the Navajo Nation Council recently approved the Arizona water settlement. Well, this was part of the ongoing leading up to that. And in some 20 years ago, the Navajo Nation filed what we call a breach of trust suit against the United States. And basically what we were saying is when you're making decisions about the Colorado River, because the Department of Interior controls access to the river below a certain point, you cannot get a drop of water without a contract with the Department of Interior. And the nation's right to that river had never been adjudicated, primarily because the United States Department of Justice never raised the claim in a case in the U.S. Supreme Court called Arizona versus California. So when they issued policies and procedures through the process in the Federal Register, how are we going to deal with shortages on the Colorado River? We'll do this, that, and the other thing. How are we going to deal with surpluses, if any, in the Colorado River? They never considered the nation's claim. They never considered the ongoing unquantified rights of the nation to that river when they said, this is yours, this is yours. So we said, at least it wasn't me, but it was attorneys in DOJ, wait a minute, you have a trust obligation in the United States to consider our rights when you make those decisions. And since you haven't done it, you breached it, we are going to make you consider those rights by suing you in federal district court. By the time it got up to the U.S. Supreme Court, we argued the treaty. And we argued provisions of the treaty, and there are provisions in there about providing seeds and cultivating agriculture. Well, how are you going to do that without water? I don't know. So what would Barboncito, Manuelito, Ganado Mucho at the time have understood? You're going to provide water. You're going to help us develop the water. You want us to become farmers and agriculturalists. In fact, Navajos were farmers and agriculturalists. But the treaty would suggest somehow they're teaching and developing this agricultural lifestyle on the reservation. Well, that's what you said in the treaty. When you say that and you don't provide water, doesn't seem to make a whole lot of sense that you're fulfilling your trust obligation to the nation. U.S. Supreme Court 5-4 disagreed and said, no, the treaty doesn't specifically tell the United States that it has to do anything related to developing water on the nation. It has to be specific or express. And this language is very broad and vague, according to them. Therefore, it didn't create an enforceable trust obligation. Now, does that mean the nation did not have rights to water? No. Did that mean the nation did not have rights to the Colorado River? No. It did not adjudicate any rights related to what actual water the nation could utilize. It was about, can you force the United States to do something affirmative to develop the nation's water resources? And the answer was no, because 5 members of the 9-member Supreme Court said the treaty wasn't sufficiently specific as to requiring that. Okay, well, that's our general presentation. There's a number of other cases that have involved a number of different issues that, because of time, we haven't included, but I do have an outline that I put together for purposes of the bar review for the Navajo Bar Association that lists all of these other cases if anyone is interested. But the main point, I think, to take away from at least our perspective is this is a living document. The treaty is alive. It is a legal means by which the nation can make the United States fulfill its promises. You treated with us under this constitutional authority to create this bilateral document. You need to live by it. And we have the ability to file in federal court. But also, the Navajo courts have conceived of this document from a Navajo perspective within the context of Huelde and Bosque Redondo and the great suffering of the Navajo people to say, Our leaders at the time were in this situation. They negotiated this to protect the sovereignty of the nation. And that's why that document is important, not just as a means to sue the federal government in federal court, but as a means of internally recognizing the sovereign rights of the nation, negotiated through the most dire, tough suffering that anybody should ever have to go through. And that's a triumph. And that is a victory. And you're not in Oklahoma. That's what Sherman wanted to do at the time. Go to Indian Territory. Barb and Cito and Navajo women leaders said, that's not happening. The most dangerous general in the history of the United States said, okay, and agreed to it. That, I think, is the greatest lesson from what was going on at that time, that they convinced this guy that he was wrong and that he needed to adhere to the wishes of the Navajo people. Thank you. And yeah, okay, I guess we're done.